Donald Trump is talking vengeance. What happens when he wins the White House? Now that he's been the victim of a bunch of DOJ prosecutions, totally illegitimate, what happens when he gets control of the wheel, when he takes over the DOJ? Is it going to be a favor returned? He says absolutely, and I certainly hope so. But the reason why Trump is under such attack from various different entities, 4 different indictments, civil suits, ballot removal suits all over the country, is because he has a big voice. He's got a big following. A lot of people are at his back, which is why the courts are trying to gag him so that he cannot talk about things like this. He cannot say that the DOJ is illegitimate. They want to stop him from causing another so-called insurrection, from rallying the people of America to support him against a weaponized DOJ. And so this is what Trump says. As soon as we're done here, we're going to see the appeal that Trump is filing to lift this gag permanently so he can have more free speech throughout the campaign season.
We will start by exposing every last crime committed by crooked Joe Biden, because now that he indicted me, we're allowed to look at him.
Fair game.
But he did real bad things. We will restore law and order to our communities. And I will direct a completely overhauled DOJ to investigate every Marxist prosecutor in America for their illegal, racist, and reverse enforcement of the law.
And they do not want that to happen, okay? These DOJ prosecutors, they are now kind of fighting for their lives, aren't they? If Trump wins, there's going to be some big consequences for their whole corrupt entity. And so you're going to see here the actual appeal that Trump has filed with the DC Circuit Court of Appeals. We're going to go through it. It's a 67-pager, and we've been following this litigation since the very beginning. The January 6th case taking place out of the DC Circuit Court. This is on appeal, and we're going to be scheduled for oral arguments in this case on November 20th, 2023. So be sure that you're subscribed so that when we cover the oral arguments and see what the Court of Appeals does, you can join us on it. But this is the big filing. It's a 67-pager, as I mentioned. It's the opening brief of Donald Trump up to the Court of Appeals, and we'll take a look at some backstory on this, but it's a big filing, and a lot of appellate memos and opening briefs have a lot of law in it. So we want to hit the highlights and tease out exactly what's going on here. But let's start off by starting with the introduction and seeing what Trump's defense is writing, saying, all right, Court of Appeals, we just got out of Judge Chutkan's courtroom. It's kind of messy down there. Let me tell you what's going on. Court of Appeals, the Supreme Court has never allowed the government to prohibit candidates from communicating relevant information to voters during an election. Never happened. And they're citing a Supreme Court case. This is a U.S. Supreme Court case from 2002. And they're telling the Court of Appeals this. They say, accordingly, no court has ever imposed a gag order on the political speech of a candidate for public office, let alone a leading candidate for president until now. Never, ever, not one time in American history has it happened. But on October 17th, Judge Chutkan issued a gag order. And the gag order restricts Trump from making public statements about key aspects of the prosecution. Now, he seeks to replace the Biden administration. All of these issues are inextricably intertwined with the 2024 campaign. And the gag order obviously violates Trump's First Amendment rights. And it also doesn't even give a whip about our rights, the audience's rights, to hear from Trump. Now, given its extraordinary nature, one would expect an extraordinary justification for the gag order, but none exists. In fact, the gag order rests entirely and wrongfully on a classic heckler's veto. Speculation that the Trump audiences might react to his speech with, quote, harassment, whatever the heck that means, or, quote, threats, all of which is already illegal, by the way. You're not allowed to do that. You can't just call and threaten people. The First Amendment forbids the heckler's veto, saying that Trump might say something that might cause somebody to do something, and therefore Trump can't speak. Obviously, if you take that to its limit, if you extended that, that would be an insane country. There would be no free speech if we were responsible for everything that everybody did after they heard something from us. So they say, even if it were legally viable, which is not, there's not even any evidence that supports any of the actual threats or harassment in the first place. Saying Trump has made many public statements about this case in the 3 months since he's been indicted. Many statements. But the DOJ has submitted no threats. They've submitted no harassment, any actual evidence that this has occurred to prosecutors, witnesses, or anybody. Instead, the prosecution themselves even admit, they say, quote, of course, this prejudice is speculative, but we're worried something might happen, and so we have to gag him now. They say, court, a prior restraint cannot be based on speculation. The court cannot silence Trump just based solely on anticipation and of the reaction of his audiences, saying Chutkan lacks the authority to muzzle the core political speech of the leading presidential candidate, and saying Trump is entitled and the American people are entitled to hear his political messages, and saying the gag order should be immediately reversed. Now, they tell us what is happening, sort of the jurisdiction, how the court got the case. They ask these two very important questions, and this is always fun on appeal. We try to ask ourselves, specifically, out of all these 67 pages, what are the two questions that we're trying to answer here? Number one, question, whether the gag order violates the First Amendment rights of both Trump and tens of millions of Americans to engage in and hear the core political speech in the middle of a presidential campaign. So his right to speak, our right to receive. And two, another issue, whether the gag order is unconstitutionally vague, so void for vagueness. Two issues. They're going to ask the Court of Appeals to respond to this. Is this unconstitutionally vague? Simple. Yes or no. Or is it going to be, does the gag order violate the rights of yes, both, no, both, or yes, one or the other on the first question? Trying to make it almost logical, like programming. So they give us the statement of the case. They say, all right, Court of Appeals, President Trump is the leading candidate for president of the United States. Even polls are showing that. New York Times, CBS, CNN. He holds dominating leads in polls for the Republican nomination, and he holds a substantial lead over Biden in polling. He's got over 100 million followers, and his public statements reach far and wide. Now, Trump, as we know, was indicted, supposedly, for, quote, obstructing official proceedings and, quote, defrauding the United States. But the indictment in this case and the issues surrounding it are inextricably intertwined with the campaign for re-election. One commenter described the issue surrounding the indictment as, quote, central to Biden's re-election argument. And Trump is literally being prosecuted by the person he's trying to beat at the ballot box. Trump's opponents, including witnesses, routinely attack him. They say Trump's not fit to be re-elected. They say the conviction should disqualify him. And Trump responds to these statements and says that this is intending to interfere with the election. Now, on the day that the indictment was filed, the special counsel prosecuting Trump gave a speech during a press conference, falsely saying that Trump's responsible for the attack on January 6th. This statement, they say, egregiously mischaracterized the indictment, and the special counsel drove negative headlines about this indictment. So in other words, Jack Smith came out and said a bunch of stuff about Trump that was not actually in the indictment, and the media went with the things that he said, which were not true, like didn't even charge him for crimes for that. So before and after the indictment, there were a long series of leaks of confidential information, all of it meant to smear Trump. Witnesses also can attack Trump. Mike Pence, Bill Barr, Mark Milley, all of them going all over the place, saying Trump's term would be a horror show, says Bill Barr. Mike Pence made similar statements before his failed campaign. And while this case is pending, Trump is engaged in core political speech, responding to his critics. He routinely posts statements about this stuff. He described the indictment. He said that they're trying to take away his free speech, but none of Trump's statements, not one of them, constitutes a threat, nor fighting words, nor incitement, nor anything advocating for imminent lawless action. And so the prosecution did not contend that they fall outside of the First Amendment or that they are part of an exception to the First Amendment. And the district court did not find that. But instead, Jack Smith moved for a gag order. But they didn't contend that Trump's comments were actual threats. Instead, the motion just gave several examples of some individuals who claimed that they got harassing, threatening communications back in 2020, years ago. The prosecution provided screenshots of Trump's social media posts calling for a federal takeover. And the prosecution said that this could possibly impact the jury panel or the witnesses, talking about little Mike Pence and other things. But the DOJ and the deranged thugs over there at Jack Smith's office, they didn't present any evidence that any prosecutor or any potential witness had actually experienced any threats or harassment at this time. No statements by Trump or any court staff that showed that they were the cause of new harassment. They filed their reply, but it didn't include any actual evidence. It's all speculative. No actual evidence that any individual actually felt those threats. And so in October, the court held a hearing on it, and they said that they might inspire third-party agents to act. When the defense team asked Judge Chutkan, when they said, Chutkan, the government has submitted no evidence to substantiate its concerns about harassment or intimidation, the judge responded, well, why should they have to submit evidence? Because you're a court, that's why. And when the district court asked the government, they said, well, why don't you have any evidence? They said, well, it's speculative. I mean, we're speculating. Now, they wanted to postpone the case until after the election, until things cooled down, but the judge said no, like we are going to trial in March because we need to. This is the only way we're going to try to stop Trump. I think it's going to backfire on him, but that's That's what their efforts are. So then Judge Chutkan held the hearing, issued the gag order, and made their determination. They said alternative measures like jury questioning are not sufficient to remedy everything, and so they've got to gag Trump. The court specifically said, I'm not giving any weight to the fact that you're conducting a political campaign. Said, I don't care about the election. I only care about our trial. And so Trump here is now in front of the court. We filed our notice and motion and opening brief in our appeals, and here is what they say. Your Honor, at the court, the gag order violates Trump's rights and 100 million Americans' rights. He's got a fundamental constitutional right to spread his core political speech and message, as do the audience. The gag orders are violating our rights. And because it violates our First Amendment rights, it's invalid on its face. Any restriction on speech requires a clear and present danger to the administration of justice. Clear and present danger, not speculative. And this is also Trump's campaign speech that's being gagged, which is some of the most protected speech in the whole country, because that is how you change the system, is by campaigning against the government. In fact, you can't sue the government when the government does something bad. They say, no, you have to, in most cases, unless you're directly harmed, they say you have to go vote. It's a political issue. It's not a legal issue. So if you have a specific claim, for many cases in this country, the only recourse is by rallying people to your cause. And in order to be able to do that, you got to be able to speak. The gag order's sole justification for the gag is that Trump's speech might, quote, hypothetically lead unidentified independent third parties to subject prosecutors and potential witnesses and court staff to harassment. This is a classic heckler's veto. It's exactly what it means. Under the First Amendment, speakers are not chargeable with danger when their audiences might react. The government cannot censor the reaction to the speakers because of the reaction of the speaker's audience. The gag order is invalid on its face, or at the very least, subject to strict, very strict scrutiny that it cannot stand. Saying the prosecution made no showing that the gag order was necessary. When the gag order was entered, the case had already been pending for 3 months. Trump had been talking about it for a long time, but there was no evidence of threats. Trump had been saying stuff since the beginning. Nothing changed. The gag order also gave no meaningful consideration to more or less restrictive measures, and they didn't find anything about it. And the gag order was also sweepingly overbroad, saying it restricts large amounts of core political speech that poses no plausible threat to the administration. It's a heckler's veto. It silences public criticism of public figures. It stops Trump from responding to people who openly attack him in media, in political debates, in books. It's impermissibly one-sided. Trump's opponents can attack him without restriction, but he is silenced from responding in kind. And it's also unconstitutionally vague. It doesn't satisfy exacting standards of clarity. The key operative word is a target, a range of meanings here. We don't know who is a reasonably foreseeable witness. Trump can't measure his conduct against that because there's 13 million pages in this case, and the government doesn't even have a witness list or even a list of potential witnesses. So we have no idea how big this is. So Trump is left only to guess what a reasonably foreseeable witness is and who that might be. And it also says Trump can't talk about the substance of their testimony, which is also indeterminate. We can't know what it is, especially months before the trial. And so the judge says that there are carve-outs, that we can have general criticism of the government. Isn't that nice? They gave Trump some permission to communicate his grievances against the government. General, though. Don't make it too harsh, okay? Our feelings might get hurt. President Trump must therefore guess when criticizing those deranged thug prosecutors. All of these problems make the gag order arbitrary and discriminatory and unconstitutionally vague, saying it violates every fundamental principle of the First Amendment. It's invalid on its face. And they're going to give us a lot of law here, so we'll fast forward through a lot of this, but you can see. It says it's not a clear and present danger. In this case called Landmark Communications, SCOTUS told us we have to have a clear and present danger. It has to be a high standard. District Court said very much the same thing, and it applies here. The gag order requires the same standard. The only evidence to support this inference of a clear and present danger, like the only fact that says it might be clear and present, is some inference from nearly 3 years old. And President Trump has made many statements about this case, and so if there was a threat of harassment or harm, wouldn't we have seen it by now? And by the way, they're also admitting that this prejudice is purely speculative, saying that this also violates the First Amendment in many ways. Prior restraint, if you're going to gag someone and muzzle them, it's got to meet the highest of standards, and it's not doing that. Also noting that this is Trump's political speech in the middle of a campaign. It is the essence of self-governance. No form of core political speech receives greater protection protection than campaign speech. Lies at the core of our process. Now, the only two cases that address gag orders on criminal defendants who are also political candidates are Ford and Brown, and they granted virtually complete exemptions for the defendant's campaign speech. In fact, the Sixth Circuit ruled in Ford. They said here, the defendant is entitled to attack the alleged political motives of the Republicans, while he claims he's persecuting him because of his political views and his race. He's entitled to fight the obvious damage to his political reputation in the press and the court of public opinion. He will soon be up for re-election, and his opponents will attack him as an indicted felon. He'll be able to respond in kind. And so, they said, virtually no restrictions on their speech. President Trump's message is specifically that the criminal cases against him are part of politically motivated, an unconstitutional campaign to silence him. It lies at the very heart of the First Amendment. And so when Chutkan tried to set bounds for Trump, they did so to cordon off what they deemed was unnecessary. And they're trying to dictate the scopes of his political campaign. All of that, of course, unconstitutional. They talk about the First Amendment, saying that the gag order has been widely criticized all over the place, and it imposes a heckler's veto. You can't chill the speech based upon the reaction to the speaker. This gag order also shields public figures from criticism. Trump can't comment on certain public figures, saying that the gag order suppresses Trump's ability to attack the special counsel. In Rosenblatt, another case, the First Amendment, we found, does not tolerate an order to shield public figures from criticism. The gag order also viewpoint limits. It discriminates against Trump. At oral argument, they said that there were concerns about Trump and Trump's comments about Mark Milley. They also brought up books and Milley being criticized. And they said that they interpreted Trump's speech out of context and then discriminated against his viewpoint. And so what the judge did is not going to survive any layer of scrutiny. No doubt, evidence was scarce. The record was relied on from outside the court record. There were misleading reports, and there are many other alternatives that could be used to protect the court that the judge didn't even consider. And says, as we conclude, that the gag order is overly broad, it's unconstitutionally vague, and that all of their other arguments are not relevant. In conclusion, at the district level court of appeals, Trump's defense says, therefore, the district court opinion and order should be reversed in its entirety. If the court affirms any portion of the order, Trump respectfully requests that the court extend the administrative stay for 7 days to permit him to seek emergency relief from the U.S. Supreme Court, which is where this is going to go. John Sauer, writing on behalf of Donald Trump, also signed off by John Lauro and Todd Blanche on behalf of the former president, submitted to the D.C. Circuit Court of Appeals. Oral argument set for November 20th. And so, my friends, we'll be here to cover that. We'll see what Trump's defense team says in the Circuit Court of Appeals. I believe that this is going to be bound for the Supreme Court, and we'll be following it as it does. Thank you for subscribing and joining us. Thank you for inviting a friend or family member to come check out our channel. Follow along with the court documents as we do, and we'll look forward to seeing you and them on the next one.